So we've already had a little look at fiduciary duties and fiduciary obligations in a previous video, and we've also had a little look at specific fiduciary relationships. But in this video, I really want to dive deep into our understanding of fiduciary duties and what the actual fiduciary duties are. And we've already mentioned a few already, which I'm going to go into a bit more depth. We mentioned about the duty to act in the best interest of the beneficiary, for example, as a trustee, or the duty to avoid conflict. And this is really what this video and the next video is going to be all about. So, as mentioned already, a fiduciary relationship implies a duty of trust. It is usually a one-way relationship. A trustee owes a beneficiary a fiduciary duty, but not vice versa. For example, your solicitor owes you a fiduciary duty, but you don't owe him a thing. You have no obligation to act in his best interest or avoid a conflict of interest. And Millett, in this case of Bristol and West Building Society, said that a fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interest may conflict. He may not act for his own benefit or for the benefit of a third party without the informed consent of his principal. This is not intended to be an exhaustive list, but it is sufficient to indicate the nature of fiduciary obligations. They are the defining characteristic of the fiduciary. So this gives some defining characteristics of the fiduciary, but it is not an exhaustive list. And although we're going to explore the general fiduciary duties that are owed by fiduciaries more generally in this video and the next video, we will look at the full duties owed specifically by trustees in a couple of videos' time as well. However, not every claim arising from a fiduciary relationship will give rise to a claim for breach of fiduciary duty. There must be a relationship between the fiduciary relationship and the act which founds the claim. In other words, breaches of fiduciary duties are breaches of trust and confidence. So to bring a claim for breach of a fiduciary duty, you have to show more than mere incompetence. So just because you have a fiduciary relationship doesn't mean that everything you do wrong is a breach of the fiduciary duty. And Fletcher Moulton in Coomber said that in some minds there arises the idea that if there is any fiduciary relation whatever, and any of these types of interference is warranted by it, they conclude that every kind of fiduciary relation justifies every kind of interference. Of course, that is absurd. The nature of the fiduciary relation must be such that it justifies the interference. So, a court will not find a breach of fiduciary duty if the breach is not fiduciary in nature. In other words, it is not a breach of trust and confidence. Thus, the existence of a relationship which might be described as automatically fiduciary in nature, does not lead automatically to the conclusion that a court will find that the fiduciary was under obligations of a fiduciary nature in relation to the matter before it. The finding will depend upon the matter in dispute falling within the ambit of the relationship of trust and confidence, which gives rise to the fiduciary relationship. And Millett said that the nature of the obligation determines the nature of the breach. The various obligations of a fiduciary merely reflect different aspects of his core duties of loyalty and fidelity. Breach of fiduciary obligation, therefore, connotes disloyalty or infidelity. Mere incompetence is not enough. A servant who loyally does his incompetent best for his master is not unfaithful and is not guilty of a breach of fiduciary duty. So this is the same idea. So negligence and incompetence is not a breach of a fiduciary duty. It may give rise to a remedy in tort, but not an equitable remedy for breach of fiduciary duty. There will only be a breach of a fiduciary duty if there is some level of disloyalty or infidelity. So, what are the fiduciary duties? What specific breaches have been held to be breaches of fiduciary duties, and thereby equitable remedies would be available? So, what I'm going to look at now and in the next video are some of the general duties that are owed where there is any type of fiduciary relationship. And we looked at those sort of fiduciary relationships that exist in the previous video. So let's have a go and have a look now. So the first sort of fiduciary duty owed by fiduciaries is about making a profit. A person in a fiduciary relationship may not make a profit from the relationship, but they are entitled to remuneration. That means really making having fair pay for the job that they do. So the solicitor owes you a fiduciary duty, but also charges you for their work. So being paid as a fiduciary is fine, but making a profit is not without the informed consent of the beneficiary. And we've got a few different cases here, and I'm just going to discuss each one so that you sort of get a general idea of how this making a profit duty works in practice. So the Boardman and Phipps case is a very important case. It's a landmark case. Boardman was a solicitor of a family trust, and the trust's assets included a 27% holding in a textile company. And this was the largest, or the single largest share in the company. By virtue of his position in relation to the company's largest shareholding, over a period of 18 months, Boardman was given access to a large amount of commercial information relating to the company's business, which was not in the public domain, including detailed accounts as to the turnover of the company's various factories. This information was treated as being confidential, as in correspondence between the directors of the company and Boardman. Now, Boardman was concerned with the accounts of the company and thought that to protect the trust, a majority shareholding is required. So, armed with all the information, he hit upon the idea of asset stripping the company so as to increase the value of all the shares in the company. Boardman realised that the company was undercapitalised and pretty badly run, and believed that with an injection of capital, change of management, restructuring, etc., this could be a very profitable company. But because the company was a private company, Boardman would have been unable to find out this information or to acquire shares in the company but for his role in relation to the trust itself. Now, to carry out this plan, it required that the trust acquire a majority shareholding in the company. The trust was not able to acquire the extra shares itself, both because the trustees did not consider the trust was in sufficient funds for the purpose, and because the trust would have required the leave of the court to make such an acquisition. Therefore, Boardman and one of the trustees, Fox, decided to acquire the shares personally, with Boardman contributing a fair amount of his own money. Boardman informed the active trustees he intended to do this. However, it was held that Boardman had not provided them with enough information to be able to rely on the defence of their consent to his plans. Their shareholding, combined with the trust shareholding, meant that Boardman and the trustees could, in effect, control the company. With a great amount of work on Boardman's part, the company actually became extremely profitable. This meant that the trust generated a lot of money, and so did Boardman himself. And that's because of the shares he had acquired. So everyone should have been pretty happy here. The company made lots of money and Boardman made lots of money. However, one pretty ungrateful person, a beneficiary of the trust, decided to sue Boardman for the profits he made. The issue was whether Boardman was entitled to keep the profits on his own share, or whether he was required to hold that profit on a constructive trust for the beneficiaries of the trust. The House of Lords held that Boardman should hold the profits on a constructive trust for the beneficiaries of the existing trust, and therefore the money Boardman had made had to be returned to the trust. Despite the fact he had acted in good faith and for the benefit of the beneficiaries who did very well out of this, the House of Lords recognised the importance of the principle they were applying. In other words, people in fiduciary relationships cannot make a profit. Boardman had breached his fiduciary duty as an advisor to the trust, so although he was not a trustee, he had a fiduciary relationship with the beneficiaries as a result of his advisory position. So this case shows how strictly the court will apply the principle that a fiduciary cannot profit. The solicitor acted in contrary to the principle that a person in a position of a fiduciary nature cannot make a profit, so he had to pay it all back minus a generous quantum of merit. So that's like a generous payment to him, as the House of Lords recognised he had done a good job nevertheless. In other words, Boardman was entitled to some sort of compensation known as equitable accounting for his efforts in spite of the imposition of the constructive trust. Okay, so that one's quite a long case because a lot of things happened in that particular case, and it's an interesting one to look at and read in more depth. So I would recommend you check out the Boardman and Phipps case. The other three cases here are a little bit shorter, and the principles that we can glean from it are a little bit quicker. So, industrial developments and Cooley. In this case, the managing director of a company, Cooley, was offering construction services, was advised by a potential client that it was not proposed to do business with the company, but was willing to place its business with the company directors personally. So we talked about this case before. So the client said to Cooley it was not prepared to do business with the company he was part of, but if Cooley wanted to do the work in his own right, he could do so. The director feigned ill health as a pretext of resignation and accepted the client's work. It was held that he was bound to account to the company for all the benefits accruing under the contract, so it was irrelevant that the information came to him privately. So Industrial Development Consultants Limited found out what had happened and argued Cooley was in breach of fiduciary duty by taking a business opportunity in conflict with his duty to act in the best interest of the company. So even though it was clear Industrial Development Consultants would not have got the contract, because it was a breach of his fiduciary duty, he was forced to pay all the money back he received from the contract. So the court is very strict on this. Even if no loss is caused to the beneficiary, as happened here, the mere fact you are in a fiduciary relationship is sufficient for the court to order them to pay the money back or hold it on constructive trust. And then we've got the case of Guinness and Saunders, and Guinness appointed a committee of directors to handle the company's affairs during a takeover bid of another company. One of the directors, Ward, was paid a £5.2 million sum as a bonus. The bonus was authorised by a committee of directors, and the Articles of Association provided that the whole board must consent to such a bonus. It was held that there was a breach of fiduciary obligation based on the terms set out in the company's Articles of Association, which could not be overruled. So the money was held on a constructive trust for the company. And finally, we got the case of Foster Bryant, and Mr. Foster and Mr. Bryant were directors of the plaintiff, which was a surveying company with FBS Limited, Foster Bryant Surveying Limited, and pretty much all of their work came from a company called Alliance. And Mrs. Bryant, who was Mr. Bryant's wife, also worked for FBS Limited until Mr. Foster said she was going to be made redundant, so she was going to be dismissed. Unsurprisingly, this made Mr. Bryant unhappy, so he resigned, and Mr. Bryant told Alliance that he and his wife were leaving, and since Alliance was concerned about a project with Mr. Bryant, it suggested that Mr. Bryant should work directly for Alliance, and Mr. Bryant accepted. Mr. Foster then issued a claim against Mr. Bryant for breach of fiduciary duty, and the court held in Mr. Bryant's favour. The court said that once he had stopped being company director, he no longer owed a fiduciary duty. Okay, I'm going to stop that here, and in the next video we're going to talk about a few other situations where we have a fiduciary duty, or what other fiduciary duties fiduciaries owe, such as acting in good faith and avoiding conflicts of interest and so on and so forth. But if you have any questions about this video, please leave a comment below and I'll get straight back to you. And if you like this video, don't forget to give this a thumbs up and subscribe to my channel. Thank you very much for watching.